All right, well, welcome back again. My name is Judge Oscar Kazin. I'm from Bexar County. I want to make one quick observation. They keep saying Bexar County, Bexar County, Bexar County. And every time we talk about some of the things we can do here, I hear, well, we're not Bexar County, okay? Well, you know, Bexar County is a 12-year success. We didn't happen overnight. I remember Judge Specia's not here, and you'll hear from him later, but I remember we had no specialty courses. Judge Specia and a couple of other of us trying to figure out how to do that. We didn't have counselors, we didn't have funding, we didn't have caseworkers, we didn't have AOTs, we didn't have drug courts, we didn't have mental health courts. We started with one person at a time, and I want to echo back to that last statement, a bite of the elephant. So just remember that. That's what this is about, all of this, getting you to where you can take that next step, where you bite the elephant until it's gone. It's still a tough chew, though, but that's how we do it. All right, here we go. And again, I want to recognize Judge Specia because he's really the one guy who kind of started it rolling with the children's drug court before we even knew what drug courts were. So, all right, back to this. Welcome back, and this is an exciting and next presentation in the session. Well, you'll learn about new innovative practices, an individual disposition docket, which admits individuals who have been diagnosed with an intellectual disability, another area of the law that we often don't speak enough about, as well as mental health and mental illness. They are charged with nonviolent criminal offenses, often found incompetent and unrestorable, and have been civilly committed through the state supporting living centers. The panel you're about to hear from are experts and can comment on the various and innovative ways we can address IDD. First, let me introduce Staci Biggar, is a Houston-based attorney who has been practicing law for over 20 years. After serving as a partner at Guerrero Biggar LLP for 15 years, she launched her own firm in 2014. Prior to a career in the private practice, Ms. Biggar served as an assistant district attorney in Harris County. Ms. Biggar specializes in criminal law, specifically mental health cases, veterans court, and mental health probate cases. This is where I tell my joke a second time. I am twice the Marine because of my belt line that I was 30 years ago. That's why it's funny. Okay, got it. All right. So next is Senior Judge Mark Kent Ellis, who has presided over the 351st Criminal District Court from 1997 to 2016. In 2001, Judge Ellis, along with Judge Mark Carter, began the Change Through Intervention Community Supervision Docket. 5 years later, Judge Ellis started the Competency Restoration Docket for felony defendants found incompetent to stand trial. In recent years, the NGRI docket, as well as the IDD docket, have been added to the over the Harris County mental health dockets. Judge Ellis currently co-presides over the 4 mental health dockets with Judge Lori Gray of the 262nd District Court. We also have Nicole Hawk, who's a statewide community continuity of services coordinator for the state-supported living centers with the HHSC. She began her career in professional IDD services at the Austin State Supported Living Center over 13 years ago. Ms. Hawk has a background in regulatory services for long-term care facilities. Ms. Hawk is a licensed master social worker in Texas. Ms. Hawk's passions for IDD services started when she was a young teenager volunteering with Buddy Baseball, an integrative sports organization for children with Down syndrome and IDD. And then last but not least, Ms. Erica Robinson-Winsor is the Harris County Mental Health Division Assistant District Attorney. Ms. Windsor started her career with Harris County District Attorneys over 8 years ago. She has been a misdemeanor prosecutor, a felony prosecutor, and for the past 6 years, a mental health prosecutor, handling both felonies and misdemeanors. She currently handles cases in which defendants have been found incompetent to stand trial, insane, or placed on specialized probation dockets. Ms. Robinson-Winsor also serves as the liaison to the Juvenile Division, advising the juvenile cases for mental health components. These are very talented individuals I've had the pleasure to work with. They're wonderful. Let's give them a loud round of applause, please. I got to make it through here.
Okay, I have to be on a plane at 5:23, so I get to go first, and I'm probably going to leave. So here we go. So I'm Mark Kent Ellis. I was an elected judge for 20 years. I'm a senior judge, an old judge, and I'm still doing mental health dockets because nobody else wants to do them. So I know what you're thinking. Harris County, we have all this stuff, and we have all this money. Well, the second one is false, but anyway, I'm here to talk to you about something that is free, that doesn't cost a dime. And every county, no matter how big or small, can do this. Okay, one more time, free, okay? So having been doing mental health dockets for 21 years and having started with probation and then competency restoration, and Denise Onken back there who's taking our picture twisted my arm until I took all the NGRIs in Harris County. Just say no. But anyway, now in the last little more than a year, we started an IDD docket. Now, I used to joke a little bit because the mental health authority in Harris County was called Mental Health and Mental Retardation. I never knew why it had the second name because they never seem to do anything for those people, but they do, and we found out. But here's what happened. Staci Biggar, who represents all of our IDD residents, went to see, was it Mejia or San Angelo?
Mejia. I went to Mejia.
Went to Mejia and to see your client and sort of ask a question, why don't y'all tell us what's going on with our people? And the answer was, well, nobody ever told us to tell you about the residents at the state supported living centers. So we made a new order, and at the bottom of the order it says, please communicate with us. Oh, I'm sorry, you're ordered to communicate with us. Now, we have an order. Well, Erica Windsor down at the end, she'll send it to you by email. You can have it. But it's a regular 46B 103 order. But at the bottom it says, please communicate. And so they started talking to us, and we started talking to them. Now, I want you to think about this. When someone goes to a state supporting living center, they go on an indefinite commitment. This is not like a mental health case where every year you have to, you have a review and you get all this information and all that stuff. They're there permanently. Now, Judge Kazin said nonviolent cases. We've got murders, we've got rapes, we've got all the serious cases and some not as serious. But these folks, many of them have been there for years and had never heard from Harris County. And so we called and talked to them and said, can we talk to our residents at Mejia, at San Angelo? The boys are at Mejia, the girls at San Angelo, and then the Richmond State Supported Living Center, which is the nearest one to Harris County. Some of our folks are there. And so we got on Zoom and we started talking. It's fun. Okay? It is good to talk to them. They like to know that someone out there knows what's going on. And we learned a whole bunch of different things. So for instance, we learned that one of our folks was stepping down to Richmond and then stepping into Harris County with a super aggravated sexual assault. Now, before we sent our order and they started communicating with us, he would have just landed somewhere in the community. Now, they do their work. I'm not saying they don't do that work, but it would have been there without any knowledge of the court. So we now are participating in that step down and working with appropriate guidelines and things that we need to do. They do fantastic work at the state level, at each of the facilities. But this is something that if you just will take the time. So we do this quarterly, every 90 days, okay? All you need is this magic order that says talk to us, and Zoom, which I'm sure all of you have figured out how to use by now since COVID, and the time. And it doesn't cost you anything to do this. And you get to meet some people. You get to learn about some people who have deficits, but it's very interesting. You will enjoy it. It's rewarding, and you'll learn something about someone from your community who's in a resident at Mejia or at San Angelo or whatever's closer to you. And then if someone is getting ready to come out, well, then you can help that process too. And so I don't care if you're in Harris County or Bexar County or Tom Green County, or if you're whatever the smallest county represented here is. We have a list.
Angelina.
Angelina, okay. So we have a list showing the counties that have someone at a state-supported living center.
That's it, right?
So if you didn't know that, it's possible you didn't know, because you may not be the judge who signed that commitment. Reach out, okay? Get our order, please, and communicate with these folks. And it's a good thing to do. It's an important thing to do, and it's easy. And again, it's free. So you don't have to have anything extra. You don't have to pay for anything. You just have to spend a little time, sign an order, get on Zoom, and communicate with these very important people. Okay, that's all I've got to say.
Thank you very much,
Thank you,
Judge. So I'd like to back up a little bit. That was sort of a crash course of our entire presentation, which is a good, now you know where we're going. So who are we talking about? So we're talking about commitments under the Texas Code of Criminal Procedure 46B 103. And one of the things that you'll notice about this order that we talked about is there's an interesting component in that there are multiple standards that we have to meet. So a person has to be a person with an intellectual disability, and that is by clear and convincing. But then further on down the line, you have to prove that they actually meet criteria to be placed in a residential placement beyond a reasonable doubt. And of course, that's the highest burden that we have, and that's the burden in a criminal case. And the reason that we have that high burden is because you are talking about this indefinite commitment. So if we are going to restrict a person's liberty potentially for the rest of their life, then we better be absolutely certain, which we all know in criminal court, that is not the definition of beyond a reasonable doubt, but that's how certain I want to be if I'm going to commit someone under this provision. The standard does not read the same as a mental health certificate of medical examination, but it is very similar. The person has to represent a substantial risk of physical impairment or injury to themselves or others, or be unable to meet their basic daily needs, which is very similar to that third prong on a certificate of medical examination. Then you also have to prove that there isn't a place that can meet their needs in your community, but that a residential treatment facility can.
And can I was just gonna put in there too, so prosecutor, defense attorney,
Facility representative.
facility representative, judge. So as the defense attorney, I think that many of my peers don't realize the difference between a 102 or a 073 and a 103, right? And so they don't realize that it's a different standard for these cases. And so what I was finding was when I went to go see my few people in Mejia, they basically said, what about all these other people here? Are you going to talk to them? And I didn't know that they existed. And so really educating for the defense bar, the judges, the people, educating that it's a different standard, that this is a different type of commitment. This is a longer term commitment, and being very careful with these people and what the decisions are that are made. I will say most of my cases are very serious cases, and they do a great job with them. But just really being more aware that even though this is a niche of a niche of a niche, it is a different standard, and so we should all look at it differently.
Well, and the other thing is, I think one of the most important things about all of our mental health dockets, no matter what you do, is the ability to help have a nice therapeutic conversation with someone, no matter what, again, even someone who has IDD, and some of them are lower functioning than others and the like, but having that conversation, and like I said, as much as anything, letting them know that you're out there, but talking to them, what's important to them, what are they doing, things like that. It makes a difference for them as well, not just it feels good to talk to them. It is an important way to help the process.
And there's an important distinction. So in restoration services, you can have the suspicion of IDD with evidence to that. But then when we get to the 103, they actually have to have a determination of intellectual developmental disability and meet an IQ criteria of 69 or below, which is a federal criteria for the SSLC ICF designation.
And as a prosecutor, this statute is incredibly important because each of us has a different duty within this system and each of us has a different goal, but we all have to work together. When I have a very serious case where a person is incompetent, unlikely to restore, but I don't feel that it would be safe to release that individual back to the community, I have a responsibility to figure out what is the alternative. And I think very often people think their immediate knee jerk is, I'm going to have to dismiss this case. And what this statute tells us is that you don't necessarily have to dismiss your case. There is another path, and we believe that it's underutilized around the state because people don't know about this code section. And it will also inform your conversations that you're having with victims and other members of your community. When people say, well, this person committed a capital murder, what are you going to do about it? I can say, well, look, I understand that this person is not going to get a life sentence, but look at what we are going to do. And by understanding what this commitment entails and what the process is, I think it can inform that conversation a lot. So we've shown you the order that we use, which is our
That's right.
next slide.
And we do see folks who have their charges dismissed and sometimes multiple charges. And over the course of time, if they move across the state, they're not necessarily, the DA in that area isn't aware that, we've had 13 breaking and entering, and this is the 14th, and they're still, and then the charges get dropped. And so that person hasn't necessarily changed their behavior.
Yeah, right. Yeah. And I will say, many of the cases that I now handle all of them. It sounds like a lot, but there's not as many as you think. But a lot of them come from the state hospitals. Mm-hmm. And so the state hospitals identify these people that should be in a different type of commitment. They've been very good at identifying them, communicating with both sides, and I believe with y'all, because we've been able to really transition them well from a hospital setting to a state.
Yeah, and so when someone is in a psychiatric crisis, you may see auditory hallucinations or delusional thinking and things like that, and the ID might be an underlying condition that because they're in such a psychiatric crisis that you're not seeing what is psychiatric issues versus a developmental disability. And so once we get someone into a state hospital environment and they start to receive regular treatment and care, we start to parse what is actually a psychiatric need versus what is a behavioral need and what is an ID need. And then we get folks assessed for the determination of intellectual disability, and our state hospital partners reach out to us. We have some regulatory differences between our treatment environments, and so we're working as a team to help transition folks to the most appropriate care setting for their needs.
Yes, and so we wanted to show you some data. We've talked about what makes these commitments different. So this is how many people historically we're talking about. This data goes through fiscal year 2021. So this is how many offenders are being admitted to state-supported living centers across the state. And then we also wanted you to see, this is from fiscal year 2020, which was the most current data that I had. I only put the ones that had more than one, so I know these totals don't add up. I know I went to law school, not math or medical school, but it does work out. But just so you can see what types of charges. You will notice on our order, we did include a finding of violence or not. Sometimes there are people, for example, a capital murderer or a sex offense, those offenders may still have to start their commitment process at Vernon and then be moved over to a state-supported living center. Luckily now we have the clearinghouse, we have the MSU waitlist, and we have all the people that work there who can look at our documentation, look at our evaluations, look at the case history, and make the determination of where a person is most appropriate. And so we do have people that are moving across, the system between those.
And we do use the MSU waiver process, and so we can actually divert someone from a state hospital directly to an SSLC if we've reviewed their case and the associate commissioners agree that that's a most appropriate care setting.
Yes. And so, the statute does require that if someone is transitioning between levels of care, or if they're receiving a furlough or something like that, then the court is typically notified of that. But what was happening in our county, and so we have 23 district courts and 16 misdemeanor courts. And what would happen is they would receive a fax that here's a letter that says that this is what's going on with this patient. And it would go into the district clerk's file, but there's nothing that alerts me, the prosecutor, or Staci, the defense attorney, or even the judge, that something has been placed in that file. So the SSLCs and HHSC on the hospital side, they were following the statute and they were notifying the county of these changes, but we were not being told directly what was going on. So we were never holding hearings or addressing whether or not we felt something like that would be appropriate. So here I am as a prosecutor, and I have someone charged with a sex offense. They've been in a state-supported living center for 12 years or 15 years. And then all of a sudden I get this letter that says this person is coming back to Harris County. And I'm thinking to myself, how in the world could this person need hospitalization for 12 years, but suddenly they're cured or they're healed and they can just come home? Well, now I know that that's not what that letter means at all. What it means is that this person is at a point in their life where they are safely able to be treated in the community. And so at this point, by having this docket, we have this exchange of information. So I know every step of the way what has been changed in this person's treatment. Did they go from a maximum security setting all the way to living almost independently, in a home environment, prepared to enter a group home in the community? Have they been working a job? Have they been having any type of education or vocational training? All of these things that have been put in place, and where I was seeing it before as surprise, here's this person that you weren't expecting, that's not actually the process at all.
Well, and actually, the process in which go to the community is very extensive, crazy extensive.
Yeah, why don't
So
you
now,
explain a little bit about how that even happens?
Yes.
Yeah, and so I can talk about that, but I also wanted to note that this docket has helped us with cases that aren't always going well as well. And so the judge is more familiar with folks who are refusing their psychiatric medication or refusing treatment and programming, and judge graciously gives them a little motivational chat, that reminds them that they're in a less restrictive environment than a jail or a prison, and that they should take advantage of that and utilize the treatment that's available to them. So it's really good then, and he knows the individuals that we're serving. So if we're like, hey judge, we need court-ordered medication for this person who's refusing treatment, he knows that person, he's checked in with them, and he's on board with helping us get that.
and I would add too, is that what I found taking over these cases with oftentimes family members really did not understand what had happened. Their loved one got arrested. They knew from the beginning that their loved one had issues, had always had these issues, and they can't understand why they were in this facility where they cannot be released or get them out. And so I think also trying to help educate the family members and also participating with state-supported living facilities and having communications with the families. The families are frustrated, and I find that in this population, oftentimes the families have been so involved and so protective their entire lives that it's very difficult to have the idea that they're placed in a facility where they're no longer being able to be somebody who, I don't know if advocate's the right word, but somebody who has input in how their treatment is going. And so they have an adjustment period quite often too, not just the adjustment period with the client. So I think that we're able to help on both sides with the family members in addition to the patients.
And so the family members come in as like a legally authorized representative or someone who's significantly involved. Sometimes, they're a parent for our youth who are involved, or a guardian for someone who's been adjudicated incompetent by a probate court. And so, we do bring the family members into what we call the IDT, which is our interdisciplinary team. And so that's constructed of our case managers, our nurses, our physicians, our psychiatrists, everyone who's involved in the care for that individual is part of our IDT, including our direct care staff. They're some of our most influential folks who are working with our individuals daily and are beside them 24/7. And so we had talked about the move process. And so someone who comes into care, they receive an initial plan of service. We call it an ISP, so their individual service plan. And throughout time, we treat their behaviors, psychiatric conditions, medical conditions, et cetera. And when the IDT gets to a point where they're like, the individual can be served in a less restrictive environment. So there's a multitude of options in the community. We have a living options discussion. And so in the living options discussion is the LIDA, which is the Local Intellectual Developmental Disability Authority. We have family members, we have the individual, we have their treatment team, and we go discipline by discipline to say, yes, this discipline feels that they can be treated in the community, maybe with this modification to treatment. Or yes, they're ready to go. And also at Mejia and San Angelo, we also have licensed sex offender treatment program providers. So we have LSAT training and treatment as well. So they're also part of the treatment team for some of our more, some of our folks who are oriented that direction. So living options discussion, this person can be treated in the community, they can be served in a less restrictive environment. And so we begin the provider search. And we look at, where do they want to go? How do they want to live? What are their preferences and strengths? What do they want to do with their lives? How can they be served in the community? Do they want to move closer to family? Some don't want to move closer to family. Some family members don't want that person to move back closer to them due to some of the offenses that may have been against a family member. So we have to take those kinds of things into consideration. With sex offenders, we have different restrictions on which environments they can live in, how close they can be to schools, how close they can be to, playgrounds and things like that. So it is a pretty intensive provider search. And also the providers have to agree that they can provide the services that individual needs.
Well, one of the things I thought was interesting is in this process, the resident will get to visit the potential group home that they're living in and actually see it and have input on that before the decision is made. Because there have been a few, where they didn't like a certain place and things like that. But I thought that was a cool idea. Just like, unlike someone in other situations, some of them have regular home visits from one of our favorites, Mr. Perea, who Miss Robinson got to know. He's charged with murder. I mean, he was charged with murder, but he's very happy and he's very childlike, I would say, which Miss Robinson didn't know when she was fighting his designation. But anyway, we all learned.
Me, it was a colleague. It wasn't me.
But anyway, he gets to go home on a fairly regular basis. And so, they're getting the client involved in the process of where they're going to be after they're in the supported living center, I thought was a cool idea. And so they get a chance to have input. So it's not just, here's where we're sending you, be happy. That's what's going to happen. So.
Yeah, and we do, once we find providers who would agree to potentially provide services, we have that, they go for a day visit, they go for an overnight visit sometimes with supervision, and they really get to see the environment. We've actually started a virtual reality headset program where we take virtual reality tours and have a video that are individuals who may not be able to leave campus as regularly, or they want to see a home that's, across the state. So we have centers across the state. There's 13 of them. And then we get to, use the virtual reality. Oftentimes, our parents or guardians who may not have gone on the visit with their loved one can see the home that they're going to, and have a little bit of input there as well. So, we've made the determination that they can be served somewhere else. We found a provider, we visited the provider, and now we're, sending a letter to an inbox at a court in one of your counties to let you know that we're moving a violent sex offender back to your county.
So somebody needs to find that fax or email, I guess, at that point, because we were missing that for years.
Yeah, but the reality is that person has had 12 years of therapeutic intervention and rehabilitation and vocational services and OTPT, speech and rehabilitation services. You know, we've done dental services, we've given them new glasses, we've given them new hearing aids, we've, you know, done all kinds of interventions with that person. We've worked on their functional behaviors, we've worked on, you know, medication appropriate to them and their psychiatric needs. And so 12 years later, you know, they've been removed from the environment they came from. They've been, you know, a participant in an outrageous amount of therapeutic intervention, and now they're a very different person than they were when they came to visit us at the.
So I bet you didn't know that all that stuff happened. It's amazing. They do fantastic work and very comprehensive work with the IDD residents. And so it's, I mean, anyway.
And I have to say, so I've been invited to sit, most of it has been by Zoom, been invited to sit in their meetings. I probably don't get to attend as many as they would like for me to attend because they almost always have them at 10 a.m., which is when we have court. However, it really is truly amazing. They know every single thing about these people. I joked to the judge, I was like, they know when they poop, when they brush their teeth, when they do whatever, like they know everything about these people, right? And so they really are looking to see what is going to be their needs and anticipate what those needs would be in the community, because they're able to take care of those needs in this controlled environment so that this person doesn't end up having some sort of decompensation or a decrease in services when they do transition to a less restrictive outpatient program.
Yeah, and so when we do transition someone, we call it a community leave and discharge plan, our CLDPs. Roughly, someone today actually in a meeting called it the manual of someone's life. And, you know, it can be an 80-page, 120-page document where we have all of these supports that are designed for this person. You know, we have teams where 2 psychiatrists are talking, so the community provider and the SSLC provider, they're having a face-to-face or a Teams meeting for each other. And they're not being sent out without supports. My staff literally go to a group home and ensure that either a bathroom modification has been made or that we know that they're going to have a compounding pharmacy for someone who, you know, needs that. And so we make sure that all those supports are in place before we ever transition the person. And then so once someone leaves an SSLC, we have post-move monitoring, which is funded through a Money Follows the Person grant. And we do a year of direct follow-up with the individual in the community placement. So we visit them towards the end, at the very least every quarter, and then they transition to enhanced community coordination with MFP IDD services in a different venue of HHSC for another 4 years after they've left. And so when we know that our individuals have forensic involvement, we've actually started involving a TST, which is a transition support team, and that's an enhanced community support. So they have a behaviorist, a psychiatrist, and some other folks make up the general makeup of the TST, but we're actually getting them involved on the front end because we know that law enforcement involvement and justice involvement is one of the leading causes for reinstitutionalization of our individuals. And so getting them involved and having those enhanced supports for our folks who are coming out with justice involvement in advance of them leaving, you know, we're making the community aware, these providers are aware, you know, and we've involved them in this process to talk about this specific individual's needs. And so the community is now more aware of who's coming, what's going on with that person. You know, sometimes the TST reaches out to local law enforcement and they know, you know, that someone's coming back.
So, like my client that would just go to the Walmart, he was mute and he was a deaf mute, and he would just steal the CDs. That was back when we had CDs and DVDs. He would just go and steal them. And then because they had been informed that he was living within that area, they knew that he wasn't being disrespectful or he wasn't doing whatever. It was a situation where he could then just be taken back and put back into where he was at, and we didn't have some horrible event take place because this person wasn't responding or acting in a way in which the police, you know, at the time would have thought a regular somebody in their circumstances should have been acting. So that's an example of where, when they're involved, they can help divert any sort of action that somebody, one of my clients might possibly have, or one of your clients might possibly have, because they're not understood to who they are and what
Right.
they are.
And also by starting the relationship with them while they're still in the state supported living center, went through the transition into the community, then that helps us to support them in the community in whatever ways we can, because we still want to stay in touch and communicate, again, in a positive way. Sometimes, like all of our clients, there is a need for admonishment, but establishing that relationship and then following that into the community, I think makes a big difference. And
Well, and I think too, on our side, we weren't necessarily aware of some of the ramifications of folks who are transitioning between counties.
Right.
So we had a gentleman, who's a violent sex offender, and you guys have him on lifetime check-ins with the court. And
Right.
so we were able to get him back to Harris County, where the originating court is responsible for him, and they'll be able to continue his check-ins, and there's not like this cross-county now responsibility for his offense.
right.
And something that's so important that Judge touched on, as a prosecutor and as a judge, we are not interacting with these individuals as the court process begins. And clinicians in the jail, in the community, their lawyer is talking to them. So I have an individual who's been charged with a heinous crime, and I've met with their next of kin. And I have looked at that person and I have said, I am going to get justice for you and for your loved one. And now I'm in a circumstance where I have a report that says that this person is not competent. And so I look at that person and I say, we're going to fight this. There's no way that someone who committed this offense could possibly present the way that this report says. And now I know from doing this, it is, this is what Judge was referencing, and why I wanted to bring it back up. Having these conversations with this individual, I cannot believe that we would have contested the competency on this case. There is no possible way that this person was ever competent, will ever be competent, and I know that now, but in my role in the system, and we still probably would have had a hearing, because that is what needs to happen in these cases, and it does allow for the complainant, for that next of kin, it allows them to see the process, it allows it to be out in open court, they can understand what's going on. It would have also made this person visible so that the family would know this is what happened, this is why we're going down this road. But if we did not have this docket, I would have never understood how this person presented, why, the finding was made this way. And it's really opened my eyes to that. There is one thing that is very important to know, and that is that in order to do this docket, you do need an order for the State Supported Living Center to communicate with you, even though the person is there under a court order. So originally we thought we were going to have to start doing subpoenas and do it in every case and have all these records sent to us. And we used to do that. We would get boxes with thousands of pages of records, which no one has time to review. But what we realized is that you can do this order. I know it's very small. You'll be getting it in the materials. The bottom paragraph, is what's important. And basically what the state is urging, the state being the prosecutor, is urging to the court that the disclosure of this information is necessary and that it is not harmful to the patient for their information to be disclosed. And then the order is all of 4 lines, 5 lines, whatever's up there, where the court says, yes, I agree, this information should be disclosed. And so this is all it takes to be able to proceed in this way. So what happens after that, what happens next is that the hope is that someone who is released to the community will continue that court involvement. So whether they're on a bond, if they're on an outpatient commitment, then they have this relationship. We have them start coming to court in person or on Zoom, whatever is appropriate. And the judge can check in, receive updates from our local mental health authority, and we can make sure that that person is staying on the right path. So we have a few minutes, so I think each of us will kind of give our...
I was just going to add to that.
Yeah, we're going to each kind of give our...
I was just going to add, and at that point, then I can make the argument to have this case dismissed. they know and are not fearful of my client anymore. And they know what sort of services and how they're being supervised and how they're back into the community. So at this point, for the defense attorneys in the room, this is a great time to be able to advocate and be able to get some final termination of that case, where in the past, when the cases really were not being paid attention to that closely, they were just kind of indefinitely ending when the jurisdiction ended. And that should not be the way that these cases proceed.
And if we know that the court is involved, we can write supports that are going to transition to a community provider that continue to support interaction with the court. And then our community living discharge plan is legally enforceable through the LIDA as their contractual responsibility to ensure that those things happen. And so if we write that in, it's no longer just kind of vaporized. It's in a document that's transitioning with this person, that's legally enforceable under our HHSC contracts, that they have to do these things, and they have to check in, and they have to make sure that this is going on.
Yes. So in closing, I think each of us kind of will give you a final thought. For me, this is by far and easily the most rewarding thing I have ever done as a prosecutor, is be involved in this docket. People say to me all the time, but you only have 21 people from Harris County that are under this commitment order. But it's 21 opportunities to actually do something. When I leave work on a day that we have had this docket, I go home knowing that I made a difference in the life of a victim, in the life of the accused person. I did something that helped HHSC. They did something that helped me. This is the system working, and it's so easy to do that I wanted to make sure we did this presentation today so that if nothing else, when you walk out the door and go back to your county, even if it's only one person that's under this order, you can do something for this one person. And I think it's really valuable.
And I would add to that, these are the people that can't be seen and aren't heard, and can't advocate for themselves. So as the defense side, that's our job. We're their voice. And so I can't see why any jurisdiction would say that this is not a necessary program. It is, because these people need all of us to be able to have a position back in the community where everybody can safely live.
And I think it's really important to note the difference of environment between a correctional facility and an SSLC. So these individuals are people who have an identified need, and they come to us and they receive treatment that's appropriate to their diagnoses and the things that are going on in their life. And I think it's been kind of educational that the SSLC is vastly different. Like, we don't have locks on the doors. Number one, no locks on the doors. But so as the SSLC, if you are starting a docket like this, we offer the opportunity for you and, your judge, your defenders, your DAs, any of your folks who are on this docket to come and visit our center to see what we actually do, and to have a tour and meet some of our staff and our directors at these facilities. So if you'd like a tour, please contact me and we can make that happen, even if it's just virtual, if you're across the state from one of our facilities.
And the thing I would add, so this being my fourth docket that we've worked on, is sometimes you get pushback, just because something's new. HHSC at the state level was a little freaked out that we wanted to have an IDD docket, but they chilled out. But sometimes you just have to say, why not?
That wasn't me.
No. Nicole is amazing and fantastic. Lawyers, okay, lawyers.
The lawyers.
But the thing is, why not? I mean, I can't think of a reason why any jurisdiction would not do this. It's and even if the number is small, that does not discount the importance of a court and lawyers and all of us working together to have good outcomes and to communicate with people who, for some of them who've been there for decades, literally. Reach out, make a difference. There's no reason not to do this. Oh yeah, and again, free. This is free. So you don't have to be in a big county. It doesn't matter what your budget is. You can do this. So there you go. and I'm going to the airport.
Let's give this panel a big round of applause. Outstanding.